There are mixed reactions to the release of convicted murderer and former Paralympian Oscar Pistorius on parole. While others believe that he served his time and deserves the pardon, others, like River Steenkamp's family, say he showed no remorse by not telling the truth. Yesterday, the Correctional Services Department granted him parole. The Blade Runner will be released in January after serving over 6 of the 13-year sentence. Pistorius was jailed for the killing of his girlfriend, River Steenkamp, on Valentine's Day in 2013. Now, to help us unpack the legalities around the granting of parole, we're joined by legal analyst Mpumelelo Zikalala. Mpumelelo, thank you for your time this afternoon. This has been a protracted battle for Oscar Pistorius. What went into the decision to grant him parole?
Good afternoon to you and also to your listeners. Well, I think the parole board was guided, or the Department of Correctional Services was guided by the Correctional Services Act. It determines when a person is eligible for parole. That was the first hurdle, determining which is the date in which we were arrested, which is the date in which we actually were sentenced, and when did you actually sentence effectively start. This has a bearing on your eligibility to attend parole, and also on your eligibility to submit over to the parole board all the information that would have been collected by the case management committee. So I think that was the first one before we even move into consideration applying your mind to the report of the committee, and also to the report where they come, or the evidence that would come from the actual victims themselves. So I think that is what caused this particular matter to drag so long, because if you are closed at the door, or you are prevented from entering this particular decision-making process at the door, because one person says, or the department in this case says, you are not yet eligible, there's no way in which you can do that unless you go to court and get permission, and then you can be able to move forward, in this case is what Oscar has done.
River Steenkamp's mother, June, through a victim impact assessment placed before the Correctional Supervision and the Parole Board, that she did not believe that Oscar had been rehabilitated. How much of what the victim's family or victim's loved one says is factored in these decisions around parole? And obviously, to be clear, June Steenkamp wasn't necessarily opposing parole for Oscar, but she was expressing that she wasn't convinced that he had been rehabilitated and has told the truth.
I think that may have been the first problem, the conundrum that you would have with as a decision maker. If a person says, I have no opposition to the parole being granted, yet at the same time you're saying the person is not rehabilitated, then it does not correlate, or it does not make rational sense to the submission that you're going to make afterwards. So I think in this case they said, let's look at what the person is saying in the first instance. If your worry is pertaining to rehabilitation, let's look at the committee report. Now, the committee report will contain information such as whatever program that you were attending whilst you were inside, the way in which you were behaving while being a detainee. Are there any forms of gangs or trouble that you were getting into while you were there? Are you a candidate that can be released and get back and be rehabilitated, back into the community? If the answer to that is yes, then it covers the fears of River Steenkamp's mother, because they will then say, based on the report that we have received, this is what we have, and there's no way in which we'll then come back and say something which is in the contrary. However, there is a loophole if you look at the Correctional Services Act. It also seems as if this is like a tick box exercise. Just as long as you attend those workshops, just as long as you get a clean and good report from the case management committee, the parole board's hands are tied in terms of deciding that you are not supposed to be released. And there's little information or little involvement in which the victims will then have. Not maybe on the side of not being listened to, but the impact of what they are saying. Because if you listen to what River's mother said, she's basically saying, I do not agree to what we need to do, because I don't think that this particular individual has been rehabilitated. So in those instances, I think there would need to come a time whether there's a much more clear explanation into the factors which are looked at by the parole board. Maybe it's the victims itself that will need to take the department to court and say to the parole board, are you taking decisions which are rational enough, taking into account that the person that you are dealing with is a person who is a detainee, so they're supposed to spend time in prison anyways. The issue of being released on parole is meant to work as a favor and not as an inherent right it is being proclaimed by our court.
There was a lot of confusion about when his sentence came into effect. The Supreme Court of Appeal issued orders on this. At some point, he was declared ineligible for parole until the Concord had to come in and confirm he was. What caused that confusion?
I think you're dealing with the two sentences that were coming from two courts. We have one that comes from the High Court. You have one which comes from the SCA, or the one that says, or the SCA judgment that said to the High Court, go and reconsider your incarceration. So then the next question would be, which one are you going to take first? Which the most rational thing to do, or to that one would have done, would be to say, at what point in time were you admitted back into this particular prison? Let's go back on that date, the date in which you spend your first night in our correctional services facilities. That's the date in which we are going to take as the one, and we start counting from there. And depending on whether the required months and years in order for you to be eligible for parole, there's only then in which you can then be eligible. But as it happens in any other system or any other dispute that may arise, whenever there are two individuals who are fighting, the only option that we have is to go to the court. And in this case, the Constitutional Court was quite clear as to what, or gave an answer as to which is the date that must be considered as the date in which Oscar Pistorius was sent to prison.
Well, what are some of these parole conditions?
Even though it's not clear, because in the statements they even said it looks like it's going to be similar to your bail conditions. So those, I would assume, would be to say, don't leave this particular facility maybe without talking to the person who's your supervisor, or someone that comes from the Department of Correctional Services who's going to look after you. Don't leave a particular jurisdiction of a place. Make sure that you don't engage in activities like taking alcohol and drugs. Make sure that you don't commit another Schedule 1 offense or find yourself in trouble with the law. I think those would be the type of conditions that would apply. And once that has been triggered, then you always go back to the system of saying, you've transgressed, let the committee deal with your transgression again, and this matter can then step back on the parole board to say, here's a person that you've been trusted with going out and being integrated into the community. However, we are now feeling that he's not doing what he's supposed to be doing. There may be another loophole, though, if you look carefully at Section 77 of the Correctional Services Act. I think the minister does have a hand in terms of the decision, or vetoing the decision that has been taken, but his vetoing of the decision is not a final decision which is taken. His only involvement is to say, have you looked at the following factors? After looking at the factors in which I'm advising you of as the minister, parole board, either confirm the decision that you have taken earlier, or say it's okay, there's nothing that you're going to amend, or saying that it's okay, however, we're going to add the following amendments, taking into account the fears that maybe be allayed by the minister in this case.
All right, Mpumelelo Zikalala, thank you for making time for us.